One of the issues that I get asked about probably more than anything else, both as a lawyer and as a mediator, is about the division of property in a divorce case. Texas is one of the few states in the country that has community property law. And I need to clarify something for you because this can be very confusing. There are other states, Florida, California being two of them, that have community property laws. But each of the states that have community property laws, their laws are different. So just because you know what happened in California or you know what happened in Florida or some other state where there's community property, don't think it's going to be the same way in Texas, because it's not. In Texas, if you acquired the property during marriage, it's community property and belongs to both of you. If one of you were to die while you're still married, half of the community property would be the surviving spouse's property outright, and the other half would go into the estate of the deceased spouse. So think in those terms. In divorce, it's very different, however, because all a judge is required to do is to divide the marital estate or the community estate in a fair and just manner. That can be anything from 55-45, 52-48, 60-40, 70-30. I had a judge tell me one time that he'd never skew it more than 70-30 because then the case would be appealed. I don't know whether that's true or not. It's just one of those things that judges say sometimes. But in any event, separate property is what you owned. And we're talking, when I say owned and I say property, this includes debts. So debts you accrue during marriage are community debts. Debts you had before marriage or property you had before marriage are your separate property. There are a few exceptions. If you inherit anything during marriage, then that is still your separate property. If you're gifted anything during marriage, that's your separate property. There are a few other things that can happen during a marriage that result in separate property, but that's the majority of them right there. The problem usually comes in determining whether you owned it before marriage or not. And if, for example, with a retirement account or a 401k account, how much of it did you have before marriage and how much of it was after marriage? All of those things can play into the cost of divorce because those things sometimes are hard to calculate. And it takes a lot of binding documents and doing all kinds of things before you come up with a resolution. One of the assets that is addressed very frequently in my mediations is the house. Now, if you bought the house after you got married, it's a community property house. But let's say that you owned a house before you got married and you sold that house and you took the money out of that house and made the down payment on the house that you bought after you got married. So now you have a house that has some separate property value and some community property value. That's when things get much more complicated. It's all about the math, and I'm not going to bore you with the mathematics right now, but it's all about how much of that purchase price was paid from your separate property and how much has been paid to reduce the mortgage from money that you've gotten during marriage. And again, like I said, it gets kind of complicated. But most lawyers, and even though I'm acting as a mediator, typically now, I can help you with all of those mathematic calculations so that it's what we called mixed character property, when you've got something that has separate property and community property. So I could probably speak a whole lot longer on this subject, and maybe I will in another video. But just keep in mind that it's very important to keep records when you have separate property and get married.